Hey, how's it going? All right. Dershowitz and Corey had a little spat, and apparently he thinks she should be held criminally responsible for what she did in this case. One of George's supporters told me that this guy actually supports George. I couldn't find any clips that support George from him, but I found this clip, and apparently he thinks that Dershowitz was incorrect when he suggested that Corey should be charged.
Now, defense attorneys, one-time prosecutors, Arthur Aidala and Mark Eiglarsh. Gentlemen, welcome to you. So this is fascinating to me. First of all, with all due respect to Ms. Corey, Arthur, a little thin-skinned?
Yeah, I mean, this is ridiculous. And just, Maggie, just so everyone's on the up and up here, I know Professor Dershowitz. I've worked on cases with him. I would love her to sue him because
so would he
would have a field day with this. I mean, and it's bad enough for her to criticize him, criticizing her, but to go and call the teacher, so to speak, to call the dean's office and start complaining about him, it's absolutely ridiculous. And what he says, and the way he said it on your show, the truth, the whole truth, and nothing but the truth, it strikes to the heart of the matter. He's very upset that she never put in that affidavit that there was evidence of injuries that could be equated to self-defense type of injury.
And that's the whole point. I mean, like I was saying, if you've got, let's say there's a lady that's being raped, and she pulls out a gun and kills a guy. All right? Now, who's the victim in that case? And everybody's going to say, well, of course the woman. Well, this is what's happening in George's case. He was being beat, and he pulled out a gun and shot somebody. So everybody's going, well, Trayvon's the victim. No. Trayvon is the assaulter. He's the attacker. He's the person who jumped on George and beat him. And people say, well, there's no evidence of that. Yes, there is evidence of that. The injuries alone are evidence of that. But anyhow, the point that I'm trying to make is the two lawyers you're about ready to see, the one on the left we've already heard, the one on the right is not pictured yet. You're going to see him, and he was in a video that I just made this morning, and apparently some people think he's a supporter of George. I disagree, and this particular clip will show that he actually believes that Corey was right and that Dershowitz was wrong in claiming that Corey overstepped her bounds and that she was committing perjury by not providing the information that pointed to George's injuries. In a way, you could look at it like this. Let's say that a woman's walking down the street, a man jumps on her and starts raping her. Okay, now she's the victim, right? At that moment, she's the victim. She reaches in her purse, pulls out her gun, and blows a hole through the guy's head and kills him. The cops come running, and they just see her there with a gun, so they arrest her and take her away. Who's the victim in this case? Of course she is. And the fact that George was being beat down for nearly a minute, begging for help while Trayvon refused to stop, who's the victim? Certainly Trayvon's not the victim, as he's sitting on top of George's chest, pounding on his face and banging his head on the concrete. And anyone that would suggest that just, is obviously not sufficiently versed in the law. So this guy's going to make the point that Corey doesn't have to bring out all the facts of the case, that all she needs to do is bring out the information that proves that there was a crime committed by George. And I'm going to show that, but right now I want to ask, before that starts, I would like you to be thinking about what exactly in the affidavit suggests that George committed a crime, because I can't find it. I've looked over the affidavit, and I don't see any crime there. They say that George confronted Trayvon. That isn't a crime, and as far as I know, there is no evidence of that. You would have thought that as a probable cause document, they would have to show it and say, look, we have evidence that he confronted Trayvon. But they just say it. This happened and that happened and he confronted and blah, blah, blah. Well, you know what? That's just a lot of hot air. There's no evidence there. Doesn't the judge require some evidence? Doesn't the judge say, how do you know that that George confronted Trayvon. Did you see it? Are there witnesses? No, nobody asked, nobody cared. They just said it. So back to the idea that this woman's being raped, and the prosecutor goes and says the woman just pulled out a gun and shot this guy. She was walking through the neighborhood, and she confronted this guy and pulled out a gun and killed him. Would it be improper for a prosecutor to do that when they have evidence and absolute knowledge that the woman was being raped? I would say yes, and that prosecutor should be held responsible for that lie or that perjury by ignoring the facts. And so the same in this case. She completely does not give the judge any information that supports George or that suggests that George had any right to even be there. And it's not her position to win the case for the prosecution. It's her position to get to the facts of the case. And I keep hearing these Trayvon supporters telling me, no, it's her position to win the case. It's not her position to find the facts. That's wrong. The defense is allowed to be biased. The defense is allowed, it's their job to win the case for George no matter what, but not with the prosecution. The prosecution's job is absolutely nothing more than to get to the facts of the case, to get to the bottom of the case, no matter where it leads, whether it supports the prosecution or the defense. That's their job. And the fact that she left out all that information is absolutely a half-truth. I mean, if you say the woman shot and killed the man, that is true, but guess what? You forgot to say that he was raping her, that he had threatened to kill her, that he was on top of her and refusing to let her go, right? So if you do all that and you say those things, well, yes, she did shoot him. That is a truth, but you left out all the other stuff. That's a half-truth. It's a lie. So when you say, the judge says, well, what happened? And you say, she shot him, Judge. Well, it's a half-truth. It's a lie because it's a half-truth.
Right, because to get the charges brought in the first place, she filed an affidavit of probable cause. It was signed by her investigator, but it is a product of the district attorney's office ultimately, and he believes it was full of half-truths. Now, it definitely didn't tell the whole story, Mark, and it didn't include exculpatory evidence for Mr. Zimmerman, evidence that would have helped Mr. Zimmerman, but it had a little disclaimer at the bottom of it saying, more is going to come. Is that good enough?
I think it is. And let me just say this. While I don't know Dershowitz personally like Al,
I'm glad he said, I think it is, because it's bullshit. Of course it's not. Like I said, how would you feel if you were the judge and the guy comes in and says, that woman killed that guy, and that's the only information we're going to give you, Judge. That woman shot and killed that guy, and that's a fact, and I'm going to sign my name to that as a prosecutor. She shot that man and killed him. Well, that's a fact. We haven't denied that. In fact, I'm sure she's not denying it. It was her gun. She's holding it in her hand when the cops come. Just like George was holding his gun. He never denied shooting Trayvon. The point is, there was a reason for it. And that is the point. The whole point. The judge should know the basic facts of the case. What are the basic facts of the case? Well, George saw somebody suspicious. He was trying to monitor his movements. Trayvon came out of the dark and punched him in the nose. We know that it happened because George had a broken nose. He banged his head on the concrete. We know it happened because his head was busted open. So if you want to tell the judge what happened, then you should tell him that George was on the ground getting his head banged when he shot Trayvon. That would be the honest truth. And it doesn't have to be full of a bunch of facts. It's just a basic fact. George was on the ground getting his head banged. And if you don't, maybe the prosecution doesn't want to believe that. Maybe they say that Trayvon wasn't banging his head on the concrete. That's fine. But the evidence points to, and all the witnesses agree, that George was on the ground and Trayvon was on top of him. So wouldn't it be prudent? Don't you think the judge should know that information? I think so. And if you deny the judge that information, is that a lie? Absolutely, just like I said in the other cases. Believe me, plenty of prosecutors have been held in contempt of court and also convicted of perjury for lying under oath. Even though you're the prosecutor, even though it's your job, you don't have a right to lie. You don't have a right to half-truths and twisting of the facts in order to win your case regardless of, what's right and what's wrong. And this has happened many times, so many times that prosecutors have done this and have paid the price.
Alan does. I absolutely, Arthur, I called him Alan.
That's okay.
I absolutely think, listen, he's wonderful. He's a wonderful professor, and Arthur as well. However, and many of the things he says, by the way, in this case are accurate. I agree that probably second degree is not the appropriate charge. Some of the other things that we're seeking just...
There are no charges that are appropriate. I mean, that's ridiculous. What charges are appropriate for a guy that's trying to defend his life? It's the most ridiculous argument. And this guy is supposedly a supporter? I don't think so.
Justice for Trayvon. No, you're seeking justice for everyone. It's not just about one person. However, I do think he steps over the line. I don't think there's a lawsuit here, but I do think he stepped over the line when he says that it's a crime, what they did in that affidavit. They do have to provide all the exculpatory evidence to the defense through the discovery process. But in this affidavit, the sole purpose is to lay out those elements of the crime that establish probable cause.
So you got to tell me, what evidence did they lay out that makes the crime? Tell me. Where is the probable cause? I see no probable cause. What arguments were made in that affidavit that created probable cause? That he was profiled? That George was profiling Trayvon? Is that probable cause? Was there a crime there? Then they say that George confronted Trayvon. Where is the evidence of that? And shouldn't the judge require some sort of evidence? If I were the judge and they brought to me that affidavit and said that George was profiling Trayvon, I'd want to know how they came to that conclusion and exactly what way do they mean that he was profiling him. Is it racially profiling? Is it profiling based on the fact that other people that looked like him were in the neighborhood robbing houses? And I'd ask, if I were the judge, I'd ask, in what way was he? How did he confront Trayvon? In what way do we have evidence that he chased him down? Do we have any evidence that suggests that in some way George confronted Trayvon? Because the information that we have from Dee Dee is that Trayvon spoke first, that Trayvon asked George a question first. So if we're to believe Dee Dee, then we have to assume that it wasn't George confronting Trayvon, but the other way around. So I just have to ask this guy on the screen right now, what evidence do we have that affidavit had any information in it that would suggest there was a crime? And this is what Dershowitz had said. There is no evidence in that affidavit to suggest there was a crime committed by George. None. So, I don't understand it. The only crime that they have him doing is shooting, but he said he shot in self-defense. So as the prosecution is standing before the judge, it's their job to point out why it is that the police refused to arrest George, why it is the DA's office refused, even to this day, why it is that the chief of police refused, and even to this day refuses to suggest George committed a crime. So we've got all the police, all the detectives, everybody in this case that has investigated it has come to the conclusion that George was not guilty, except for Corey and her few people that studied it for a couple weeks and came to a conclusion. And if we base their conclusion on the information that they put in that affidavit, it's half-truths and falsehoods. So it's their job to lay out to the judge the basic facts of the case, and they didn't do so. So not only that, they left it so that it looks like George is guilty of something that he's not guilty of. The judge needed to know that George had claimed self-defense, but it's not in the affidavit. The judge needed to know that there were injuries to George's head, but that was not included. How can the judge make a decision on whether a case is self-defense or not? How can the judge even make any decision on the case, whether it should go to trial, whether it should go any further, anything like that, if he doesn't have the facts of the case? So to get to the facts, he depends on the prosecutor. It's the prosecutor's job to come to the judge and say, this is why we believe this. My personal belief is the judge didn't do his job properly, because it is the judge's job to question when an affidavit is so weak and so light. Why didn't the judge ask these questions? Why didn't the judge just come right out and say, wait a minute now, let me get this straight. You're suggesting that George killed the guy. Now, George isn't denying that, right? That's right. So then what's the case? Why are we even having a case? If George is admitting that he killed the guy, then why are, what are we doing here? I mean, this is a open and shut case, right? I mean, we've got George who admits that he shot the guy, and we've got a dead kid. So what else is there, right? And if we went by just this affidavit, that's what we would assume, that George just went out and killed a kid, chased him through the neighborhood, confronted him, and shot him, killed him in cold blood. That's what they want us to believe.
That's it. I don't understand where he's coming from when he claims that it's a crime and they should be prosecuted for this affidavit.
He really does believe. Listen to a little bit more, Alan Dershowitz, and then you'll pick it up, Arthur.
Right from the beginning, the prosecution knew that Zimmerman had bruises in the back of his head. They knew he had a broken nose. They had access to the full-face photograph. They knew the forensics. They just submitted false affidavits and generated the media frenzy. The finger of responsibility points clearly at the prosecutor. She raised expectations by politically indicting Zimmerman for second-degree murder when there was never any basis.
And that's been my argument all along. It's a political indictment. It was completely done through the state, outside of our normal system. In the normal system, we have the police that look at a case, and then they bring all their evidence to the DA's office, and the DA's office makes a decision on whether to bring the case to trial or not. And it's a good system. We do that on purpose, because that way the people that are charged with bringing the case to court and making it happen get to make the final decision on whether they believe there's enough evidence to make it happen, because they have a limited amount of resources. They have limited amount of lawyers to work the cases and money to spend on these cases. In the state of Florida, it's not, we're not unlimited funds. So when we look at a case, we say, that one's just not prosecutable. This one over here, maybe 50-50, maybe even less. We're not going to waste our money on it. We're going to go for those cases that we feel will make the biggest bang for the buck. For the governor to override the DA's office, override the police department, even after they've done a thorough investigation and made their points, for the governor to do that, it's a real problem for us here in Florida, because now the cost of this case is going to be so outrageous, and it's all going to come out of the pockets of Floridians. The governor appoints Corey, and her job is to stop riots. That's her job. At the time, we were having a lot of innocent people being victimized by groups of Trayvon supporters, people that felt like Trayvon wasn't getting fair justice. So the way that they could get justice for Trayvon is to go and beat the hell out of people who happen to be white. Somehow or another, they felt that that was the way to make their case that racism is bad. So racism's bad, so let's beat up white people.
And he says it was gamesmanship, Arthur, for her not to reveal some of that information to the court until after it found there was probable cause to arrest this guy or to charge this guy.
Well, Megan, how about this? I'm hesitant to say that Dershowitz is right, because I could be sued next, right? In other words, if I say he's right, I'm doing the same thing she's saying Dershowitz did, which is criticizing, really technically criticizing the way she went forward on this.
That's his opinion. How does she even arguably threaten to sue him over his opinion?
There's no libel. There's no slander. Harvard is backing him up.
It's his opinion, but it's his legal expert opinion. And he is one of the guys that they would call, like, for example, if you're having a trial and you need an expert witness, you want an expert witness concerning the law, you would go to him to ask specific questions about the law, because, or you could go out and do the research yourself. But this guy is like a walking library. He's tried so many cases, and he argues the cases based on case law. So he knows all these thousands and thousands of cases inside and out. He knows which ones went to trial, which ones went to appeal, which ones won, which ones went to the Supreme Court, whether the Supreme Court ruled in favor of this or that, all these things over the many, many years of his practice. So when he gives his opinion on a legal matter, it's pretty much a settled case, unless somehow or another someone can prove that he's wrong. And the way you would prove that he's wrong is to point out by coming to case law and saying, look, we've done this before. So anybody that wants to argue he's wrong, the way to do that would be very simple. Just point out some cases where the prosecution was able to put out a paper-thin affidavit without any information concerning the case except that information that supports the prosecution. And any information that backs up the defense would be withheld from the judge. Show me those cases where that has been acceptable, where the judge just says, sure, no problem. We don't need to have all the information. All we want is the one side of the information so we can have a trial. We don't need to know what the defense's arguments are. We don't need that. All we need is what the prosecution says so we can go to trial. And that's wrong. Before we go to trial, we always should have all the information. We don't need every piece. Like in this case, we don't need to know to make this decision whether we go to trial or not. We don't need to know every fact of the case in order to make this affidavit. But in the affidavit, here's the things that a proper affidavit would have. The outline of the story. George was going to the store. He saw Trayvon. He looked suspicious. He tried monitoring Trayvon's movements as he moved through the neighborhood, and George was on the phone with police. These aren't things that were in the affidavit, about the phone call to the police and that George is waiting for the police to come. And then, of course, the most important part of the affidavit would be where George shot Trayvon and what prompted the shooting. Don't you think the judge would want to know that? Oh, Trayvon got shot. Oh, then we need to have a trial. No. There should be what caused the shooting. Did George have any reason to shoot Trayvon? Was he just chasing him around shooting at him? What was the point? But according to the affidavit, George confronted and then shot Trayvon. And if you just go by that, you would assume that George is just a racist. He only shot him because he's black.
The truth is an absolute defense. It's only if he said something that was factually wrong.
Right.
Like if he said she just guessed about this, then he's
Mark,
vulnerable.
Opinion is protected. He is allowed to give his opinion that she committed a crime in his view. And that could also be a colloquial expression, like it's a crime. What she has done, according to him, is to call up Harvard and threatened to sue Harvard Law School, try to get Alan Dershowitz disciplined by the Bar Association, and threatened to file charges against Dershowitz as well for libel and slander.
I agree she shouldn't do that, but I can understand her frustration. Let me explain. For sure, more details should have been included in that probable cause affidavit so we can get a more fair view of this case.
I'm so glad that he said that, because that's the reason that the Dr. Dershowitz was so upset, because there was no information about this case in that affidavit. None. And the little tiny bit that they did include in there was biased and crooked and not to the point. There was no information there. They had no evidence to back up their arguments. So when you make an argument in an affidavit, and remember, an affidavit is a true statement. It's a statement that a person that signs it is swearing under oath is true. So if you swear under oath, what happens if you lie? Well, if you lie or I lie, we go to jail. In fact, a lot of people go to jail. You know that George's wife is facing perjury charges right now for not telling the whole truth. She didn't tell about the money.
However, it's not the obligation of the prosecutors to include everything in there. And what he's saying is she committed perjury. His explanation for perjury is that she only gave a portion of the evidence. So that's a half-truth. A half-truth is not a full truth, so it's a lie. And if you lie, it's perjury. But that's a stretch, and that's misleading, Mr. Dershowitz.
But no. Here's the...
See, and this is what this guy keeps saying on the right. He keeps saying that it's not the prosecution's job to say all the information. And I agree with that. And this is what we've been saying. It is not the prosecution's job to give the judge the entire case all in the affidavit. The affidavit is a very small document where you just lay out the specifics of the case. This happened, that happened. We just went over all that. So, a true affidavit would give out those specifics. And that George shot because he said, this is important, whether it's true or not, the judge should know what happened in the case. And George said that he shot in self-defense. Whether it's true or not, now they could have put in the affidavit that George claimed to have shot in self-defense. And, that's at the point that he shot Trayvon is when he claimed self-defense. That's when the stand your ground law kicks in, as soon as he says, hey, I did it in self-defense. So it was the prosecution's job to let the judge know that, and they didn't. That is perjury, because they signed the document that said that they're telling the truth, the whole truth, and nothing but the truth. It doesn't have to be every single detail, but the most important details, such as, I shot him because he was beating my head on the concrete. Do you think that would be important information for the affidavit? I think so.
If you speak to Alan
Arthur.
If you speak to Alan Dershowitz, he gives you the case law, the site where it says a partial truth is a lie. It's not like he's doing this off the top of his head.
It's not like messing with just anybody.
Hold on 1 second here. So, it's his testimony. There's law that says that law enforcement officers and prosecutors must include every favorable detail in the arrest affidavit.
And here's where he keeps trying to twist it. And this really rubs me wrong. Every detail. He keeps saying, every favorable detail? Are you telling me that the prosecution has to list every favorable detail? No, nobody said that. I didn't say that. That guy didn't say it. Dershowitz didn't say it. Nobody said that. That's why we call that a red herring argument. It is not the argument that's being made. The argument that's being made is that the specific main points of the affidavit, there should be something in the affidavit that says that George was in fear for his life, or at least that he said he was in fear for his life. How many words would that take? How many sentences do you think that it would have wasted? I know they just wanted to get 1 or 2 pages. Fine. But at the very bottom, they could have put all the crap that they did, and then at the very bottom in little tiny letters wrote, George said he was in fear for his life. We disagree. Something. No, they didn't do that. That is a lie.
So now we're talking about what, 200-300 page arrest affidavits from now on?
So see what he said? Now we need 200 or 300 pages so that we can give every detail. No, we don't have to give every detail. Just a few. Just the main points. We don't have to point out. We didn't need to put in the affidavit what George said Trayvon was saying at the time, like, I'm going to kill you, or the bashing of the head and the breaking. We don't need all that. All we need is to say, the only thing they needed to say is that the witnesses say that George was getting beat up, or George was on the bottom, and George said that he was fearing for his life. That's it. We don't need 200, 300 pages. A sentence, a half a sentence, 3 words, George felt fear. No. This guy is obviously not a George supporter.
I think
Arthur, and then I gotta go.
There's a reasonableness. In other words, something like that self-defense evidence, that has to be presented to the judge.
And that's what I'm saying. It has to be reasonable. If Corey wants to make the point that George committed that crime, at the very minimum, he should have she should have pointed out George's argument for defense at the very minimum, if not pointed out all the obvious specifics, the witnesses' statements. One witness said this, another witness said that. So, we're going to take it to trial so that we can get all the information out. That's not what happened. And so, I hate to say it, but the guy on the right, he's way off. He's way out of line. He's off bounds. And I don't, again, I don't know where he's learning law. It's just weird that somebody would think that they could just create this document out of thin air and just put in the stuff that supports the prosecution. And remember, the prosecution doesn't have enough evidence, obviously, just based on the frickin' document. But beyond that, not a single police officer agreed with prosecuting George. Not a single district attorney's, no one in the district attorney's office supported charging George. Nobody anywhere in the proper process of investigating this case came to the conclusion George should be tried for this case. Only after the governor appointed this woman, this special prosecutor, outside the law, extra legal, nothing to do whatsoever with the legal system and the way we do things here. It just doesn't make any sense to me why the governor would do that, and how it is that Corey would make this indictment and refuse to impanel a grand jury. I mean, it would have been so easy. All she had to do is say, we need a grand jury to make this decision. I'm not going to do it. And she would have been out of the picture. Would have been simple. The grand jury would have looked at it, thrown it out, and this would have been the end of the case. She couldn't do that because her job was to stop riots. So anyhow, my main point was to point out that the guy on the right is obviously not supporting George, and he obviously doesn't know the facts. He doesn't know how the law works, and he obviously is trying to twist it because he's suggesting that he's throwing out this red herring, suggesting that, oh, well, if the prosecution has to bring out any points that are favorable to the defense, then they have to bring out every point that's favorable to the defense. And that's just not true. Just the main points, the points that matter. George was fighting for his life, so he claimed. I mean, as a prosecutor, you don't have to defend him in the case, but at the very minimum, you have to tell the judge, what's up?